the appointed time and we have a quorum. I call the meeting to order. Please invite the administration to join us. Members, I believe that you have received the response papers from the administration. It covers the issues raised on the meeting on the 15th of September and also views expressed in the public hearing. We'll ask the administration to take us through the paper shortly. I welcome Ms. Joyce Ho, Principal Assistant Secretary, Financial Services, and a number of representatives from the SFC, Mr. James Shipton, Mr. Andrew Young, Mr. Derek Sheck, Ms. Clara Chiu, and Acting Senior Assistant Law Draftsman, Ms. Selina Lau. I now ask the administration to take us through the paper. I believe you have received it. It's CB bracket 11274 bracket 02. Thank you, Chairman. This covers issues raised in the last meeting, and we supply through this paper supplementary information, and I'd like to take the opportunity to explain further about the number of issues raised, one of which is the merits of the approach. And in paragraphs 5 to 6, you will find the information. 5 to 8. Let me say that we will give limited additional power to the SFC. In other words, if a regulator outside Hong Kong requests information that the SFC doesn't have, then the power may be exercised. The SFC may only provide assistance when information is to be sought from the licensed corporation. Very often, the SFC, for regulatory purpose, will seek information. So very often, the information does not have to be sought from the licensed corporation. But this power is missing from the SFC. As a result, the SFC is not in a position to enter mutual regulatory arrangements. So even when it's necessary, the SFC is not in a position to seek information from regulators outside Hong Kong to ensure Hong Kong's financial stability or to see whether there is any non-compliance. Very often, there are requests for assistance from SFCs before entities are allowed to enter into overseas market. That's why we ask for this additional power. Another issue is about the proposed mechanism and the comparison between this and other jurisdictions. We have supplied the information in paragraphs 10 to 17. We have covered mutual legal assistance in criminal matters and also the exchange of information in relation to tax. For those other exchange of information in relation to tax or criminal matters, they are arrangements that are legally binding. And as a result, if it is to take effect, it has to be done by way of a subsidiary legislation. But in relation to our current proposal, when it comes to these exchange and cooperation, it is done by way of a mutual memorandum of understandings, which is not legally binding and is subject to the restrictions of domestic law. As a result, the SFC does not have a room to enter into memorandum of understandings with legally binding effects. Another consideration is, say, for example, in relation to surrender of fugitive offenders and also mutual legal assistance. Well, they set out arrangements in relation to certain demands. Our proposal is so that SFCs can offer assistance or seek assistance from other regulators. And under our proposal, there is no requirement to enter premises. And under Section 186, under Cap 1865, well, the SFC will upload signed supervisory MOUs on its website. And in order to enhance transparency, the SFC is required under Section 186, subsection 5 to publish in the Gazette the names of the regulators outside Hong Kong when they have entered MOUs. And they will also enhance communications and exchange with the industry to better understand their concerns. Mr. Christopher Zhang, you have questions to ask? Yes, thank you. The Legal Services Division has asked some questions in relation to cross-border on-site visits, and I would like to seek some clarifications from the SFC. In the Annex 4 in the CB bracket 1 in relation to cross-border on-site visit in paragraph 6, it says that there are some overseas authorities that have the power to conduct cross-border on-site visits. They have extraterritorial powers. Who are these regulators? And do they have the power to conduct on-site visits in Hong Kong? I think it is in relation to a paper of the last meeting. Well, first of all, I'd like to ask if there are any questions in relation to the paper just presented. Mr. Zhang, maybe your question will be dealt with later because we will discuss the issue you've just raised. Mr. Sin Chung Kai. Thank you. In relation to paragraph 9, in relation to EU members, you have cited 3 member countries, that is Germany, the Netherlands, and United Kingdom. Well, but what about the practice in the US? So what's the approach of the US? Who is to take this, Mr. Shipton?
I actually happened to be in Washington and the United States, Washington and New York last week, and I discussed this very point with the regulatory commissions there. My understanding from my discussions with the regulatory commissions in the United States that their subpoena powers are so broad that they do not need a specific enabling piece of legislation to provide for the mechanisms which are envisaged by the bill. This appears to contrast with the European, including the United Kingdom, Singapore, and Australian legal status, where a specific power has been granted by the legislatures there to enable the provision. Since our analysis, unlike the United States, is that we don't have a general power, we believe that this power needs to be enabled, and hence the proposal under the bill.
佢唔需要一個法例。
There is no need to have a specific legislation, however. When it comes to the operation, what is it like? Do they have to enter into MOUs with other jurisdictions? It's just that their regulator doesn't need additional powers. But what about the MOUs? Are they subject to any restrictions?
Mr.
Shipton.
Mr. Sin, there's an important context to make because, of course, we actually haven't entered into an MOU to provide for this power yet.
But how about, United States versus other European countries?
Versus other, well, and this is where it's worth noting that the original catalyst for this particular proposal came out of Europe. The catalyst was an ability for Hong Kong private funds to market their funds into Europe. The European regulators in the European countries required of Hong Kong a memorandum of understanding that provided for the power that we are seeking. That was the original catalyst to this. In addition to that original catalyst is a recognition that this power is very beneficial for broad global supervisory cooperation across borders and boundaries. But I think the best response I can make to your question is that right now the MOUs being requested of us out of Europe have a specific wish for this power. And that specific wish and those MOUs are directly related to market access by Hong Kong firms, which would not ordinarily be granted to those Hong Kong firms but for the existence of these MOUs. And secondly, it will then also provide, we believe, enhanced supervisory cooperation across borders, which is important given the global nature of markets and many financial intermediaries, not all financial intermediaries. So at this stage, the bulk of the interest in the activity is coming from Europe. We are in discussions with the United States about MOUs, but up until the point in time that we have, hopefully have the power, we're not really in a position to go much further than we are today when it comes to negotiating MOUs.
Any other questions? No? If there are no other questions, then we have noted this paper from the administration.
Just now, Mr. Christopher Chang raised a question. Ms. Ho, do you have anything in response? Thank you, Chairman. With regards to Mr. Chang's question, in our response to the legal advisor this morning, we actually provided a paper to members, and hopefully members would have received it. And in that paper, we mentioned authorities outside of Hong Kong, for example, the United States. They can be empowered with cross-border capabilities based on the law and in their jurisdiction, and they would have the power to regulate certain corporations to conduct cross-border visits. These corporations would not be regulated by the laws of Hong Kong or the SFC. Perhaps the SFC can explain more.
May, Mr. Chairman. In response to Mr. Chung's question, I would like to also clarify that cross-border on-site visits are not caught by the proposed bill. This is a separate existing supervisory cooperation mechanism, which is governed by MOU arrangements that we have, and has been mentioned. The United States is a particularly good example of a jurisdiction who have regulatory bodies who do conduct on-site visits across borders, including in Hong Kong, and they do notify us. There are also examples of European regulators coming to Hong Kong and again conducting on-site visits here. But I do want to just again emphasize that the cross-border on-site visits is an pre-existing supervisory tool which is very commonly used. The United States will visit, I know, for instance, the United Kingdom. The United Kingdom will visit the United States. Regulators operating across borders, particularly in a Western Hemisphere sense, is an existing precedent both in the Western Hemisphere and here in Hong Kong.
Mr. Zhang. Does this ordinance only apply to Hong Kong corporations registered in the U.S.? For companies registered in Hong Kong or other countries, this ordinance no longer applies. Is that correct? Mr. Shipton.
Clarify the proposed bill before the Council. It only relates to licensed corporations that either are regulated in a second jurisdiction or have a related corporation that is regulated in that second jurisdiction. So if I understand the question correctly, I believe that the answer is that only in the case of, in relation to this bill, the provisions would only apply to when there is in effect regulation in two jurisdictions. But going back to the on-site visit point, which again is separate and existing to the current proposal, our understanding of on-site visits from a foreign regulator comes about because the Hong Kong licensed corporation has submitted to the jurisdiction of that third country, or there is some form of consolidated supervision that comes from that third country. That's our understanding of how cross-border on-site visits would work. And I think the conclusion from that statement would be if there is no supervisory or regulated connection to a third country, then a on-site visit would be inappropriate and would not occur. It only occurs when there has been a submission to that third country jurisdiction. But again, I do stress that cross-border on-site visits is not within scope of the bill, and what I'm talking about and explaining relates to existing supervisory tools.
Is that clear?
I just want to follow up on the cross-border on-site visits arrangement. It just seems to me that under paragraph C of the government's answer, the cross-border visit arrangement are purely an arrangement between the foreign regulator and the regulated entity. The FC normally would just stand back and let those arrangements happen. But I'm just wondering if the regulated entity in Hong Kong, for some reasons, resists that request for on-site visit. Has such incident happened before? And if such incident happens, what under the current arrangement or the MOUs signed by the SFC would SFC be involved in such scenario?
Thank you for the question, Mr. Long. I am not aware of any licensed corporation in Hong Kong that has refused an on-site visit. It's probably opportune for me to say that they're not common either. They don't occur frequently. when they do occur, they are usually, from our understanding, because you are absolutely correct, we do not have any direct involvement, nor do we support or supplement those cross-border on-site visits ourselves. In the event that there was a refusal by a licensed corporation to submit to an overseas on-site visit, that would be a matter between the overseas regulator and the licensed corporation, and would not ordinarily involve us, and we would not insert ourselves into such a discussion.
Okay.
Mr. Chang. All right. So basically, the government has responded to the legal advisor's question. If we have no further questions from members, let's move on to the next part of the agenda, which is a clause-by-clause examination of the bill. Let's invite the Principal Assistant Secretary to bring us through the clause by clause. I suggest members to refer to the marked up copy prepared by the Secretariat, and part 2 of the bill is on amendments relating to printed licenses and certificates of registration, and the existing arrangement for licensed corporations to show their registration remains unchanged. On the marked up copy, page 1 to 6, the amendments are to reflect this change. We suggest to amend clause 116 and 117, section 116 to 117, to require a printed copy to be produced, and the parts 120 to 121 are on the change of format of notification. We also introduced a new clause to stipulate that the licenses issued by SFC would no longer show individual names, and since the SFC would no longer issue printed licenses, the bill would take away the requirement to return the licenses. And in page 13, it's a technical change, and it's on the approval and transfer of accreditation. Any questions, Mr. Sin Chung Kai? Is this relevant to the objectives of this bill? For this bill, we talked about regulatory cooperation with the SFC, but we do have some minor amendments under this bill. This has been mentioned in the LegCo brief. Part 2 is contains more straightforward amendments. Any other questions? Let's continue. Thank you, Chairman. On page 15, it's another technical amendment. We would abolish section 133 on the arrangements to return the license and the relevant penalties. And on pages 16 to 17, we have further technical amendments, and the changes to section 124 on duplicate license, and 127, the variation of regulated activity. The key is to stipulate that the SFC would only issue printed licenses and registrations to corporations. And on page 22, we would insert an interpretation on the printed license. Mr. Kenneth Leung, does it mean that you have no, you won't have any more printed licenses, or what? What's the purpose of this amendment? Is it to save money? I don't know why this amendment is necessary. Thank you, Chairman. Let me try to explain this. Our recommendation is to take away the requirement to hold a printed license by the licensee. A license corporation is still required to have a printed license, and we will still issue that. Under our ordinance, a license corporation is only required to produce or display the license in their premises, and in a lot of the cases, the license would not be produced in their premises anyway. On our SFC website, the latest list of licensed corporations and licensees have been listed. Hopefully, the licensed representative can be saved from too much hassles, and we can educate investors. We will step up education on investors so that they know to refer to the SFC website for the latest updates on the requirements. Let's move on. Next, on the marked up copy, page 24. From this point on, from subsections 2 and 4, they are amendments to the licensing rules, and these are all technical amendments to reflect the fact that the SSC would only issue printed licenses and registration certificates to license holders and license corporations. And then page 35 to 98, part 2, division 5, contains amendments to Securities and Futures Amendment Ordinance 2014, and this is to regulate over-the-counter products, and there are amendments to Schedule 11. And during this transitional period, we would issue Schedule 11 on the registration certificates, which would be stipulate the scope of the regulated activities. The recommendation helps intermediaries show their clients a physical proof, and this is to safeguard public interests. And from page 44 to 93, these are all technical amendments to reflect that during this transitional period, the SFC would only issue printed licenses to licensed corporations. All right, let's move on to page 94. And in Schedule 11, we introduce a new part called 5A. And this is to provide for to define Schedule 11 printed license and certificate of registration. And for pages 94 and 5, this is to stipulate that in the transitional period, the intermediaries would be issued Schedule 11 printed licenses or certificates of registration, and this is to show that these intermediaries are registered to carry out regulated activities.
Pages 95 and 96, the amendments is to specify that if an intermediary is has its capacity as a registered entity seized, the license will have to be surrendered to the SFC, and it also contains reasonable excuse as defenses. But that's part 2. And now page 100 is part 3. It is on page 1990 in the English version. It is amendments to the SFO relating to supervisory assistance to regulators. In Chinese, 101 page 100 and 107 in relation to the provision. Well, apart from providing assistance to an investigation, we will amend Section 179 to add supervisory assistance to specify that Section 179 is related only to assistance to investigations. Now, page 110 is a Section 180. This is in relation to the supervisory power in relation to intermediaries and their associated entities. We will add 4A in relation to in cases when assistance is provided in relation to a licensed corporation, then production of documents and provision of information is amended to say that information only related to the regulated activities may be provided. Now we move on to 119 in Chinese. That is the new 2A. That is in relation to SFC providing supervisory assistance under specified circumstances. First, the regulator outside Hong Kong has to perform a function that is similar to that of the SFC, and the request for assistance have to be in line with interest of the public. Thirdly, the regulator will have to provide a written statement in confirmation with Section 2D, saying that they cannot obtain the information through other reasonable means, and they cannot fully ascertain the matters described in subsection 2B, that is in relation to the corporation and the associated corporations, whether it will pose systemic risk to the jurisdiction, and also some other regulatory matters. And the regulator will have to comply with the written undertaking in 2E. 2E includes those set out in page 121. This is to prevent onward disclosure or use of information that is not authorized. So we require the regulator to provide a written undertaking to the SFC stating that the information obtained from the SFC upon the request is only used to ascertain matters described in subsection 2B, and the information is treated as confidential and without the consent of the SFC for any purpose disclose the information to anybody else. And on receiving a demand legally enforceable under the laws, then reasonably practicable, the SFC should be informed, and all appropriate measures will have to be taken to keep confidentiality. And they will cooperate with the SFC in any actions or proceedings. Any questions? No. Legal advisor, any questions? Legal advisor. My question is related to the new 2D, new 2EB under 2, saying that, taking all appropriate measures. Sorry, speaker's not really coming through. But when there is but it's not limited to asserting legal exemptions or privileges. And if there are discrepancies, what will the authority do to as a safeguard? It says in the bracket that it is including but not limited to. And it also says that there are other ways that is not limited to exemptions. I will defer to Mr. Young.
The translation was very garbled. I'm afraid I didn't really get the question. I only got part of it. Sorry.
Perhaps it will be repeated. Please ask the question again. Legal advisor.
Section 186 2E, and then in the paragraph D, subsection in the paragraph 2, it is said that the written undertaking referred to in subsection 2AB must be to the effect that the authority or the regulatory organizations will, on receiving a demand legally enforceable under the laws of the jurisdiction of the authority or regulatory organization for the disclosure of any of the information, assist in preserving the confidentiality of the information by taking all the appropriate measures as may be available. My question is, what if the other jurisdictions, they does not have such legal measures such as the legal exemptions or the privileges under that law of the jurisdictions? What other measures will be available to protect the licensed corporations?
All right, thank you. I didn't get that the first time round.
Yes.
I mean, we anticipate that most other jurisdictions that we will be dealing with will have equivalents to public interest immunity or something along those lines. Most of the common law jurisdictions, the US and UK and other jurisdictions will have something similar to that. To the extent that they don't have PII, they may well have other protections, and I mean it'll be jurisdiction specific, and we would work with the local regulator to see what possible legal avenues were available and pursue them as best we can.
Legal advisor.
For example, the LPP or the right against the self-incriminations. But would you say that these protections are adequate?
Mr. Young?
Well, I mean, as I say, most of the jurisdictions that we would be dealing with, US, in Europe as well, they would have legal professional privilege, they would have public interest immunity, they would have equivalent, I mean, they may not be exact, but they will be very, very similar. Certainly all common law jurisdictions will have that. But I mean, there may be alternative protections available as well. It really is. I mean, it's impossible to be prescriptive. It will depend on the jurisdiction.
Okay, huh?
Let me ask the question slowly. I would like to refer to 119 and 120 in relation to new 2 capital A, bracket small a. In the opinion of the Commission, 1, the authority or regulatory organization satisfy the requirements referred to subsections 5A and B. Does it refer to A and B on page 124? Yes. If that is the case, then my question is, will the public know that in the opinion of the SFC, what are A and B? That is any, say for example, schedules or public documents, so that the public will know what regulatory organization satisfies the SFC requirements. Thank you. If the SFC enters into MOUs with any regulators, according to the law, the SFC will have to gazette the names of the regulators. I would defer to Mr. Shipton.
Mr. Shipton?
Yes, so we will firstly gazette the names of the regulators with whom we enter into supervisory cooperation arrangements. And then in the ordinary course, we would also publish those MOU arrangements so that it would be very clear to the public and all interested parties the scope and extent to which we have entered into supervisory cooperation arrangements with different regulators. And I must stress that there will be differences on this whole point of reciprocity, which we've consistently sort of confirmed, that only where there is a reciprocal ability to enter into such an arrangement as envisaged by the bill, and there is a reciprocal desire to enter into such arrangements, including, for instance, granting market access, only then will we enter into it. This is a discretionary power as far as we are concerned. It is not a mandatory power, and it is entirely possible that many MOU arrangements, or not, let me rephrase that, it's entirely possible that not all MOU arrangements that we enter into with other jurisdictions would include provisions envisaged by this bill. That said, we do expect a significant degree of interest from the Western Hemisphere and desire to enter into MOU arrangements, including provisions as envisaged by the bill that we're discussing.
Then I'd like to ask some other questions. Is it easy for the public in the future to find out? Perhaps the SFC will sign other MOUs other than those in relation to exchange of information. So will it be easy for the public to find out, say, for example, on a list or in a schedule, all the powers that will be given? The text of the MOUs will be made available on the SFC website. You can click a link, I think, for you to see the whole list. I know that. I know that it's supposed to be transparent. It's very good that the public can find out about it, but will there be an easy way for the public to find out what jurisdictions, what countries are covered in relation to this exchange of information arrangements?
Exchange of information arrangements will invariably differ from different jurisdictions to different jurisdictions. So the level of transparency which we believe is appropriate is to make available all of the MOU arrangements that we enter into, of course subject to very rare requests, which I'm actually not aware of any to date, that would forbid or disallow us to publish those arrangements. So putting that very rare and unlikely event to one side, we will publish the full text of each supervisory MOU arrangement. And it will be very clear inside those MOU arrangements that there will be provisions relating to the exchange of information. So it would be very clear to interested parties to search and readily obtain an understanding as to whether an arrangement with a particular jurisdiction includes the incremental power that is envisaged by this bill. I also know, because it's been said to me already, that many legal advisors watch very closely the MOU arrangements between different jurisdictions because they are advising their clients, many of whom operate across borders and are fully aware and fully appreciate of the likelihood of exchange of information even under existing measures at the moment.
Any other questions from members? Mr. Sin, I have a question on 2C, on page 121. And it says that the corporation specified for the purposes of subsection 2B is one that's, and then two conditions are mentioned. First, one that is regulated by the authority or regulatory organization, and is a licensed corporation or a related corporation of a licensed corporation. Can you explain specifically what a related corporation is? 2C, A and B is connected by the word and. So in other words, the licensed corporation must be one mentioned by the same one mentioned by the authority or regulatory organization, and under condition B, it must also be a licensed corporation under the SFC. If the corporation is regulated by the authority, or if it is a licensed corporation of or related or corporation, then this licensed corporation might not be regulated by SFC, but if it's a related corporation of a licensed corporation, then it's also regulated by the overseas regulator. Under 2C brackets B, it says a licensed corporation or a related corporation of a licensed corporation. I understand what a licensed corporation, the SFC, is. What about a related corporation of a licensed corporation? Would the SFC have such information? Mr. Shipton.
As I believe this is submitted in written papers, but the words related corporation is defined under the ordinance, under the Securities and Futures Ordinance, and essentially it refers to a holding company, a subsidiary of the same holding company, and the thresholds are composition of control of the composition of the board, control of half the voting rights, or holding half of issued capital. That's a well established and recognised definition of related corporations. But I think, Mr. Sin, you're also alluding to the fact as to pre or in advance of transparency of what companies constitute a related corporation. That would be outside of our scope, because at any given time there could be any number of different related corporations existing overseas, and of course again the scope must be that related company or related corporation has to be regulated overseas for it to fall within the boundaries of the provision proposed by the bill.
主席啊，呢個咧，我覺得係有少少，我唔知係咪應該有個問題去講啊。你客
objectively speaking, just now, as Mr. Shipton said, according to your initial description, you talked about the number of directors and so on. Then the definition is very complicated. But if you use a more layman word, a related corporation might be a competitor of a licensed corporation. I think there's a specific definition. Yes, Chairman. According to the Securities Ordinance, Section 3 listed the definition of a related corporation. Can you show me that ordinance, because I have to make it very clear? Can you show us the relevant SFO so we know what it says? Our legal advisor has a copy, apparently. So can the legal advisor read it out, please? Can you read out the definition, please? Mr. Sin. You can read out the English. I'm confident that I will understand it. We have a Chinese version as well. Can the legal advisor read it out, please? I'm sure a lot of people would like to know. Let me describe the related corporation under the SFO. If we have more than one corporation in which if the company is a subsidiary company or holding company of a licensed corporation, then it's seen as a related corporation And if the corporation contains one or more corporations with a voting right or the majority holding right, then all the relevant corporations would be seen as related corporations. And this has been defined in Clause 3. The legal advisor mentioned the word individual. This is irrelevant to this bill because we are only targeting corporations. Any further questions from Mr. Sin? Perhaps we can move on first. Ms. Ho, please continue. All right. On to page 123. So for section 186, this part listed the protection afforded to the SFC. The requested assistance must be of public interest, and it must be safeguarded by the relevant privacy clauses. Chairman, I have another question. After receiving the request for assistance, would they notify the affected individuals? Chairman, our recommendation is that if SFC doesn't have the information of requests, the SFC should be able to obtain such information from the relevant licensed corporation, so they would be notified. What if you have such information? According to the existing legislation, the SFC would pass on the information to the overseas regulator. So, in other words, the corporations won't be notified. In the new proposal, after receiving a request from you, can they object to the request if they find it unreasonable? If they have reasonable grounds, the SFC would consider their application, and this has been covered under the existing ordinance. What does it mean by having a reasonable excuse? If I don't like the SFC's decision, can I launch an appeal? Who can I turn to, Mr. Shipton?
There are a number of potential grounds for having a reasonable excuse, including, for instance, the right against self-incrimination. There is also grounds for legal professional privilege, and we would be open to receiving whatever grounds a licensed corporation may present to us in response to a request. Any request for information that is envisaged by this bill will be very clearly identifiable to the licensed corporation because we will be mentioning the sections. And because we mention the sections and the subsections that we are seeking the information under, that will then give notice to the licensed corporation that this information is in relation, is being requested by a overseas or non-Hong Kong regulator. And then, of course, it is an existing provision that an appeal or a request not to adhere to the information request on reasonable grounds could be granted. And, of course, at all times, any decision, including this particular circumstance, is judicially reviewable.
Apart from a judicial review, would there be any appeals board available to tackle appeals under the existing recommendation or proposal?
Not be any separate appeal mechanisms. We believe that because of the multiple safeguards, including the undertakings, which we'll come on to in a minute, that there are a range of inbuilt protections that protect the interests of the licensed corporation, remembering that this provision only relates to licensed corporations. It does not apply to individuals. So, assuming that those provisions and protections are adhered to, and also given that it is very well established and well recognised by corporations operating across borders and across markets, that there is exchange of information for supervisory purposes, which is separate to enforcement purposes, given that this is a well-established exchange of information mechanism already, we do not believe that an appeal mechanism, in addition to the existing rights to judicially review any decision by the Commission, is necessary or needed.
Mr. Chang, if I remember correctly, I asked the same question as Mr. Sin earlier. The provision of information to overseas regulators, whether the SFC would notify the licensed corporation, and the answer from SFC was yes. But from what I heard, if the SFC already is in control of such information, then they wouldn't need to notify the licensed corporations again. Mr. Shipton, if the SFC already has such information on hand, they won't need to notify the licensed corporation being investigated on.
Would Mr. Chung make one clarification, is that this is not relating to an investigation. The information exchanges that take place under the existing arrangements, and the distinction is between existing arrangements are well established, that there is an ability, provided that the gateways are met, and there are protections such as it is in the best interest and expedient for the public. It is not an unnecessary drain on resources on the Commission, that there would not be a notification to the licensed corporation in relation to supervisory exchange of information when that information is already on hand. There is a distinction to be made with the proposal before the Legislative Council, and that is when we do not have information to hand, and that is when we would, by force of the requesting letter, put the licensed corporation on notice that the information being requested is for the purposes of a non-Hong Kong regulator. I hope this distinction is clear.
Chairman, I have a question. In relation to exchange of information and information sought under an investigation, what's the difference? Well, an exchange of information may one day become information related to an investigation. So what's the difference? Because just now you said that there is a distinction, because in some cases the person being investigated will have to be informed. So I would like to know the distinction. Mr. Shipton.
Again, all of the MOU arrangements that and information exchange arrangements we have when it comes to supervisory cooperation, we exchange information with our supervisory counterparts under the arrangement via the MOUs that this is for supervisory purposes only. And that is the current protocol. If information is to be wished to be used by another regulator for enforcement purposes, then the existing arrangements and protocols would deem it necessary that a separate information request be submitted via the enforcement MOU arrangements that would then govern that information exchange and the use of that information via the non-Hong Kong regulator.
清楚。陳俊佳議員，
So in relation to 2B, I still have some questions. That is page 120, 2 capital B. Go ahead. So whether to provide assistance or not depends on small a, whether it constitutes a risk to or may affect the financial stability of the jurisdiction of the authority or regulatory organization, or it's likely, well, or may pose an impact on the financial stability. But this is rather broad because you don't know what the licensed corporation would do. You receive a request for information. But what if the corporation does not actually carry on any actual business? Say, for example, if there is a Hong Kong corporation which goes to Germany or the US to open a branch, then the regulator asks us for information, yes. But what if the corporation stays only in Hong Kong? But under A, it covers practically everything. So what do you mean? You mean a company doesn't have any business in the other jurisdiction, and if that is the case, it should not be subject to their jurisdiction. Oh, but under A, it may affect that corporation. Mr. Shipton, perhaps let me give you some background information. 2 capital B. In the public public consultation, we've heard the view from the industry, and we've added this. They asked whether frivolous information will be sought. That's why we added this in 2B, stating that the information, whether the information constitutes a risk to financial stability or compliance. And this provision has been supported by the trade. I will defer to Mr. Shipton about details. Well, you have added something. You have narrowed the scope. Of course, it's an improvement, but even with that, it is still quite wide. Let me give you an example. Well, there is a Hong Kong organization. That organization doesn't conduct any business in the other jurisdiction, and there's no plan to do so. Say, for example, Christopher's company applies for a license in the UK, and they seek information from you, of course. But what if Christopher doesn't plan to conduct any business in the UK? But under 2BA, you have to give the information. Miss Ho? There is still Section 180 on page 110. For the request of information, there is another limitation. It has to be related to regulated activities. So if there is no activities whatsoever, so it will not be caught. Where? Page 110. But it's also elaborated in 2C. If it's not a corporation registered over there, then they will not be able to seek any information. Nobody's about corporation registered in Hong Kong. Well, let's turn to page 110. It's section 180 for capital A. This is in relation to information to be provided. It will have to be related to any regulated activities carried on by the corporation. By your example, there is no regulated activity carried on by that corporation, so there is no need to provide the information as a result. And this is very clear. Mr. Shipton?
Supplement. I think the example, Mr. Sin, that you use is the chairman is correct that there would not be a nexus in the two jurisdictions in that case. There has to be a regulatory nexus relating to securities or securities compliance or financial stability in effect in that second jurisdiction. And if there is not activities being undertaken or a registration in that second jurisdiction, then the provisions would not apply. It's also worth emphasising that there's another provision which we'll come on to in a minute, which requires confirmation from the second country regulator that the information is for the purposes of determining financial stability or compliance with their own regulations. That gives us an ability, us as in the SFC, to go back and question and query the non-Hong Kong regulator to see whether there are sufficient grounds to justify such a request, because we are cognizant and aware that we do not want this provision to be used as a fishing expedition, and we do not want this provision to be used for unintended purposes, and I know that everybody is in complete agreement in relation to that. Because at the end of the day, this proposal only provides us with a discretion to be able to grant the information. It does not mandate us to give the information if we do have concerns or reservations that the information is not for the purposes of financial stability, which is an important subject matter, or the information is not for the purposes of compliance with securities regulation. There is a final point that I know Ms. Ho will come on to in a minute, which is essentially that another confirmation has to be obtained before we can provide this narrow form of supervisory assistance. And that is that second regulator, that non-Hong Kong regulator, cannot get the information itself, because it is very common in the existing arrangements in the financial markets globally, and as I mentioned before in relation to another matter, if a group company submits to the regulation of another regulator, then it is likely to adhere to information requests directly from that regulator. Therefore, we believe that in the vast majority of cases where information is required by a non-Hong Kong regulator, they may go direct. And if they can go direct to get that information, then there's no need to use this provision. That said, this provision is very important because it is required as an important backstop for market access, because it's required by jurisdictions like the European Union. And secondly, there will be times where it is legitimate and appropriate that another regulator wishes to verify or obtain via the SFC information that does relate to either financial stability or adherence to rules in that jurisdiction.
I have another question in relation to whether to inform the corporation to which information is sold. Perhaps Ms. Ho can answer me this. Well, if you have the information, you don't have to ask, you can just give it directly. And you said this is not an investigation. Not an investigation related to a particular case. So can you require them to inform the SFC to inform the affected parties? Say, for example, you're asked for information about a security company. And if you have the information, you supply the information, and at the same time you inform the affected organization. Right? Ms. Ho? Mr. Shipton, please.
To confirm, Mr. Sin, there is no provision when it comes to exchange of supervisory information that is already in our possession to notify the relevant licensed corporation. I would stress, though, as a matter of practice, that this is well established internationally, and the information that is usually requested and usually discussed across different regulators, such as, for instance, in supervisory college meetings, which are very well established, very important to global financial stability. There is discussion between regulators of, in effect, their own regulatory and supervisory assistance. The information that usually is discussed and information that is usually exchanged usually relates to, let's call it the assessment or the risk assessments or the analysis by a regulator of a licensed corporation for supervisory purposes. Rarely, at least in my experience, rarely is there a request for a particular piece of data or a trade reference. Again, that is because when we are dealing with financial groups that operate across borders, the foreign or the non-Hong Kong regulator will usually go direct to that group itself to seek that particular trade or information data. What regulators are ordinarily interested in exchanging when it comes to this information exchange that you're referring to, that is in the vast majority of cases, that really comes down to our own confidential assessments of licensed corporations, which of course is very important, because to exchange views as to the risk weighting, the regulatory assessments of firms operating and regulated across borders is a vitally important and well-established mechanism when it comes to global regulatory cooperation. And again, a very useful example is these very well-established colleges, supervisory colleges, which exist globally and indeed regionally for these important risk and supervisory assessments. And again, I make the distinction that this is not investigatory in nature, but this is supervisory in nature, which is more oversight and preventative.
我都覺得有少
I think it's contradictory to a certain extent. Well, when it comes to giving of information by the SFC, when the non-Hong Kong regulator asks the affected license organization and fail to do so, then the non-Hong Kong regulator will come to you. But according to what Mr. Shipton said, and of course, the information related to risk assessment, then the non-Hong Kong regulator will definitely not know about it, because all they know about is just some general information. So I would like to ask, what information can the SFC give them? Those related to the annual report, trade data? How many clients do they have? So the only information that is not in the public domain is the assessment by the SFC, what you've just said. And of course, the licensed corporation itself will not have the information, so that means at all times this mechanism will be triggered.
Do you mean that whenever they obtain information, they have to notify the relevant corporation, right? I just find what he said contradictory. On one hand, he said we don't necessarily have to provide the information as long as the licensed corporation can provide the information directly, the SFC won't provide the data. My second question is that when you provide such data, can you notify the affected licensed corporation? And the answer was no, because the information provided is the assessment by the SFC on the relevant licensed corporation, and this is the corporations would not have a copy of SFC's assessment on themselves. So if, apart from the fact that you won't provide your own opinion, what kind of information would not be disclosed? What kind of information you have possession of would not be disclosed? Mr. Shipton.
Mr. Sin, thank you. Let me try and clarify the situation, because we're talking about two different types of information exchange. So the first type of information exchange, which is envisaged by the bill, is in effect the request by another regulator for information that we do not already have that is of supervisory interest for financial stability or compliance purposes to that non-Hong Kong regulator. We agree that because that information is not of supervisory interest to us, but is of supervisory interest to another regulator, and is being requested by that other regulator, that extra provisions need to attach to that particular information request. And that particular information request, you are correct in saying, probably and most likely is going to relate to trade data or specific information from a licensed corporation in the case of Hong Kong. But as I mentioned in relation to that first example, that first type of information exchange, if that foreign regulator, that non-Hong Kong regulator, can get the information via other mechanisms, then we will not accept the request to provide it ourselves, because that is an important protection, and this is something that the industry requested of us in the consultation, which we totally agree with, because if there are existing mechanisms by a non-Hong Kong regulator to get that information directly from a licensed corporation, as I said, because they have already submitted to that non-Hong Kong regulator's regime, then that is the appropriate mechanism to do that. I then spoke about a second suite of information exchanges, which is in effect the existing arrangements that we have in place. And I was making the observation that in the vast majority of cases under the existing exchange of information between regulators, because that was the question which I believe was of interest, that the vast majority of information that is exchanged between a regulator is a risk assessment, or a good example would be a copy of a recent inspections report or a copy of a thematic review that would be of interest potentially to another regulator. And equally, it's very valuable for us at the SFC to receive copies of these inspections reports or inspection findings when it comes to, again, organisations that operate across boundaries and operate across borders. That is the vast majority of information exchanges, and that was a typical exchange of information and a typical exchange that would take place in relation to a supervisory college, which is a good example. So I hope I've made the distinction clear, because it's certainly not contradictory in nature, but we are dealing with different types of information exchanges under different circumstances, and that is why it's important to differentiate the protections and the procedures that which we believe is entirely appropriate for seeking bespoke information for another regulator, which is the subject matter of the bill, versus exchanging information under current arrangements.
Mr. Kenneth Leung.
Just get a confirmation from the government that the safeguards regarding the provision of supervisory information here would be identical to the existing safeguards accorded to the licensed corporation under Section 186. It's exactly the same type of safeguards.
For the existing safeguards, they are identical, but and then we added additional safeguards especially for the supervisory cooperation.
So the additional safeguards, as I can read, would be down under mainly 2E and then 2B, or all these provisions, right? One of the safeguards I would like to ask is about the information obtained under the supervisory regime, that is under 2E, subsection A. The regulator of a foreign jurisdiction can only use the information obtained for the purposes of sustaining its supervisory regime and not starting an investigation, right? That is affirmative. But on the other hand, of course, they can use information obtained from your assistance to investigation cases for supervisory purposes. Is that correct? Just tweaking the questions in another way.
Could you repeat the tweet, please, Mr. Long?
My question is, the information or the assistance you provide under an investigation, those information, can they be used for administer the supervisory regime?
There are actually strict, right now inside the SFC, there are strict information rules relating to information obtained for investigatory purposes. Mm-hmm. So, for instance, I work in the supervision department. I am not privy to information that is gathered for investigatory purposes in relation to a licensed corporation. Of course, at the end of the investigation, if there is an issue that is announceable, then we receive information. But there is strict internal guidelines in relation to the flow of information from the enforcement division to any other division.
Yeah, but what you're talking about is internal guideline, but it's not in the law book itself, the legislation itself, to prevent the flow of information deriving from an investigation case to a supervisory regime. Whereas you have got the provision here preventing the flow of information deriving from a supervisory regime to start off an investigation case. So that's the question I'm asking. Why is there such a difference here?
Well, forgive me, I don't quite follow the question, but I will try nonetheless, for the purposes of the discussion, take it forward. Of course, the provisions and the safeguards here are trying to enforce or persuade and regulate our arrangements with another regulator. We need to make that crystal clear in legislation and in MOUs that we have a very clear design that any information that we provide under this bill is only for supervisory purposes. I'm not sure I quite follow how our internal guidelines because if our internal guidelines are referable in relation to investigation. In fact, in many respects, I see them as consistent because we do treat information gathered for investigatory purposes by the enforcement department separate and distinct and protected internally, and that is in many respects consistent with the bifurcation and the distinction that we're applying here, that information is only under this proposal for the use for supervisory purposes and not investigatory or for the purposes of proceedings.
No, I understand that. My question is, if you assist a foreign regulator in an investigation case and you obtain the information, you would pass some of the information to the foreign regulator. Of course, I mean, that is a natural process, that the foreign regulator would obtain some information regarding the investigation, right? Okay. And upon the receipt of this particular information, What I'm asking is, can they use this information to kick off or start off another inquiry for supervisory purposes, or to kick off another, investigation case, not related to the first one, but is there any restriction in the use of information imposed on the foreign regulator in this respect? Because you're restricting them from using the supervisory information to kick off investigation because they have to, make a new request. But on the other hand, you don't have a provision to stop the foreign regulator to use the piece of information deriving from an investigation case to, start an inquiry on the supervisory regime. Yeah. Is my question relevant?
Let me try and respond, and I'll also ask our senior counsel, Mr. Young, to supplement. The rules relating to exchange of information for investigatory purposes are separate and distinct from what we're discussing today, and I'll ask Mr. Young to speak to those because he's an expert on on those rules. But I'm not quite sure whether the protections which would apply there I would expect solve for the concerns that you have, that if there's an investigation to investigation exchange of information, that's the area that would be in need of protection, because of course you're dealing with matters of potentially going to enforcement processes and procedures. And of course, at the end of investigations, any regulator should be put on notice for supervisory purposes what is the follow-on action after any disciplinary action. So I can speak for at least, obviously none of us can speak to another regulator, but I can speak to what we do at the SFC is that after an enforcement action has been decided upon, that is of course very relevant and important information for ongoing supervisory purposes, and we will make sure that whatever the lessons to be learned from an enforcement action in relation to a licensed corporation are embedded into that organisation so that mistakes don't happen or situations don't happen twice. But just going back to the important part, which is the protections in and around exchange of information for enforcement and investigatory purposes, I'll ask Mr. Young if he would like to supplement.
Mr. Young?
Yeah, thanks, James. Of course, the regime for enforcement cooperation has been in place for many years. The multilateral memorandum of understanding that most jurisdictions are a party to, including the SFC, sponsored by the International Organization of Securities Commissions. It has specific provisions in it dealing with permissible uses of information. So therefore, if an investigation request comes in, it states the purpose for which the information is sought, and those are the purposes for which the information may be used, and only those purposes. And of course, that's much more intrusive than anything in the supervisory context. I mean, that involves compelling evidence, and it can involve search and seizure and all sorts of things. So it's a completely different order of magnitude compared to the sort of activity we're talking about here.
Okay.
Thank you.
Let's continue. Mr. Sin, when this bill is enacted, would you have additional internal control, say, for example, internal audit? Of course, you already have an internal audit. Apart from that, do you have anything else internally to check that you comply with this provision? Say, for example, well, there is no activities conducted. However, you have given the information. Any internal safeguard?
And thank you for that question. The answer is that we will, and actually we do have internal guidelines now on the exercise of information exchange powers. And we actually have outlined draft internal guidelines in relation to the powers envisaged by the bill We, of course, are also subject to the process review panel, which reports to the Legislative Council, and it would be open to the process review panel to look at the procedures that we apply in relation to any matter that is subject of the PRP's mandate, and we would expect that they will take an interest in the fullness and time in this subject matter.
No other questions? Please continue. Thank you. We can turn to 126, part 4. This is part 4. The amendment is to clarify matters related to carrying on of business operations upon revocation or suspension of license or registration. It's to clarify that they still have the duty to comply with the relevant rules and regulations. Please turn to page 126. There is addition of 118 and 1B. This is in relation to intermediaries. The Commission may by notice in writing permit the intermediary to carry on business operations connected with a revoked activity that are essential for closing down the business of the revoked activity. And the specified persons may carry on the business operations. And page 127, this is in the case of when the registration or license of an intermediary is suspended, and the business related to protection of interests of clients may be conducted. And in relation to 2A and 2B, that is in relation to specified person or intermediaries. Well, despite the revocation, it is deemed that the license or registration is not revoked, because in this way all the requirements and regulations still apply to these organizations. Any questions? No? Please continue. Please turn to 140, part 5. This is in relation to a proposal, because currently under section 378 in relation to onward disclosure. But the fact is that, well, when it comes to the exchange in relation to listed corporations, the listed corporations will have to inform the insurers or the auditors. But because of the current limitation, very often the listed company will have to seek the consent of the SFC. However, listing rules is enforced by the exchange, so the Commission is not involved at all. We just would like to, through this amendment, empower a recognized exchange to give onward disclosure. This is only to improve administrative efficiency. Let's now turn to page 146. Sorry. 145, part 6. That is amendment relating to delegation of function. It's a simple amendment. Under the current provisions, the SFC may make available materials to or circular in relation to intermediaries, but this function cannot be delegated. But we propose that this function may be delegated so that it can be more effectively carried out. Next is page 146, part 7. This is to adjust the levy to the closest cent, because under the current levy, imposition of levy, well, there is a percentage involved, but because of this, there may be less than 1 cent. so it can't be collected. So we propose to add 2A to round the levy amount, whether it is a fraction of a cent, the amount is to be rounded to the nearest cent. Yes. Say for example, 115 to 119, then it will be adjusted to 0.12. We have actually taken reference from similar ordinance. It's a suggestion of the law draftsman that the way it is worded, it means what you just said, that if it's below 4 cents, it will be rounded down. If it's above 5, that will be rounded up. For 147 to 148 is to amend sections 10 and 13. That is to replace 0.10 cents to replace 0.10 in the place of 0.108, because well, currently there are 3 decimal places, so we have proposed to make the adjustments. For 149 to 151 is to amend the Securities and Futures Investor Compensation Levy rules based on the same reason, to add 2A, that is, in relation of the levy amount, if it is less than a cent, it will be rounded to the nearest cent. Let's move on to 152. This is a minor amendment. Say, for example, on page 152, the Chinese version, section 307, subsection 1 is amended to align it with the English version. 158 is also a minor amendment to correct a mistake. So the contract notes, statements of account and receipts rules, the mention of subsection 5 is corrected to subsection 4, which is correct. Next is 165 to 220. They are the same amendment. That is in relation to voting shares. In part 15, in relation to a disclosure of interests, originally it was decided by shares whether one has the duty to vote. However, that is changed, so we have to have some consequential amendment to change the wording. Under section 308, these are the consequential amendments that you will find on pages 165 to 220. I think that's all. Any questions? If there are no questions, Mr. Zhang, you have something to say? No, so far I don't see any controversial issues. Well, we have completed the scrutiny of this bill. I would like to see if you have any proposed amendments from members. Mr. Zhang, if you have anything to say, say it loudly, please. No other questions? Any proposed CSAs? No? The government will not propose any either. Legal advisor. So in relation to the provisions we have covered, do you have anything to say? At this stage, I cannot propose any amendments yet. Don't worry, you will have time to consider. We finished today's meeting. The scrutiny of the bills completed. So I'd like to ask the administration, when will you resume second reading? And then we'll give time for members to consider possible amendments, because we have to work out the deadline of notice, etc. We will inform the clerk. If there are no other questions, the meeting's finished. Members will be informed about the timing. If there are no further amendments, we will not have another meeting. The clerk will work out the time with the administration. The meeting's adjourned.